Ladies and gentlemen, welcome to the People's Law School. It is a great honor for us to present to you this program and the best lawyers in America. Tonight we have Kerri Riley, and she's a good one. You know, when I was in law school about 40 years ago, actually more than that, I finished 40 years ago, but I graduated, there were 231 students, law students, that showed up to begin law school. When we finished 3 years later, there were 175 of us that finished. Do you know how many girls there were in my class? 6. And it was a man's game. I mentioned that to you because along comes Kerri Riley, who I will tell you is a real trial lawyer. She is. She's straight. When she got out of law school about 10 years after me, she, by golly, tried the best cases and the big cases. And she didn't do this, what I call a little girly practice, where you really don't get in front of the jury and you really avoid things. Kerri Riley has, by golly, delivered in every aspect of the case. She's a real jury trial lawyer. She wouldn't, there's no, how do I say it, when she has no fear. She's done an extraordinary job in regard to all of the jury verdicts and things she's gotten. She got the one of the really the first Americans with Disabilities Act case in our district. She got the first verdict. She's gotten other sexual harassment type verdicts, which is an area of the law that is new game and new territory for a lot of us. Kerri has always been in the pursuit of excellence. She's a local girl. She grew up right here in Huntsville, finished over at Lee High School, where she was the valedictorian of her class. She went on to Alabama and received her degree in chemical engineering, and then went on to law school, and by then had a couple of girls. They were twins and still are. And she went through all that, and in regard to the topic, she said, and I learned a lot about it, not just in law school, but also on the oil rig I worked on when I was in college. So this girl spent one summer on an oil rig working with all the men while she was getting her engineering degree. But she has been in private practice since 1993, and I want you to know, I'm proud to know her. She does an extraordinary job. And if I consult her often to determine what we ought to do in a particular case, and I salute her, and I'm so glad to have her here tonight. She's going to talk to us about sexual harassment. Ms. Kerri Riley. Thank you for coming.
Thank you, Alan. Thank you. Maybe I better quit while I'm ahead. I'm Kerri Riley, and it's a pleasure to be back here this evening. I see a few familiar faces, but a whole lot of new ones this year, which is very exciting. Before I get started, I'll tell you just a little bit about my practice. I do a whole range of general litigation, almost all litigation and trial work from the plaintiff's side, very few defense cases, a few small businesses, because just like I'm a small business, they're mostly plaintiffs. If they get into trouble and need a lawyer. But no big companies, no insurance companies are among my clients. I do car accidents, as we heard Mr. Prince earlier today, products liability lawsuits, because I have an interest with an engineering degree, some fraud and whistleblowing from time to time. But I have to say that probably 50% of my practice is employment law, and a great deal of that is sexual harassment law. Alan mentioned to you that when I started, there just weren't very many female faces out there in the law practice, and I have to say that sexual harassment was a newfangled idea, and most of the employers didn't really think much of it. In fact, most of the older lawyers I knew didn't really think much of it. So it was something that I was able to involve myself in, and I didn't have much competition. And I might have had a few personal experiences along the way as well. But at any rate, times have really changed. Unfortunately, bad behavior has not changed, human beings being what they are. And so I still have a fair number of sexual harassment cases. Since we've got some new faces and probably have some new viewers out who'll be watching this on television, I'll do a little bit of review about the law as it relates to employment and all forms of discrimination. And if you've listened to me before, you know that the state of Alabama is an employment at will state. And that means an employee can be fired for any reason at all, or no reason, or a good reason, or a bad reason. An employer does not have to keep you employed even if you are a stellar employee doing a great job. Other states are not like that, and we sometimes get transplanted people to Alabama who've come from a right-to-work state, where if an employer wants to fire an employee, they have to have a reason, and that is not the case here in Alabama, and sometimes I have to, unfortunately, explain that to new persons to the state of Alabama who don't understand that they may not have the employment rights that they're used to. In Alabama, we do have some employee protections if you are injured on the job. If you're injured on the job, you cannot be fired for filing a workers' compensation claim. And we also have an age discrimination statute. But other than that, if you're relying upon state law, good luck. The employer pretty much can do what they want in terms of terminating an employee. Now, under federal law, it's different. We have Title VII, which prohibits discrimination based on age, race, sex, national origin, ethnicity, disability, pregnancy. I always forget one or two, but you've all read the sign. And in that case, you may have employment rights if you are terminated from your job because of one of these wrongful reasons. That because of, though, is a big step and a big hurdle to successfully pursuing an employment law case. If you're in the state of Alabama and you believe that you have been adversely affected in your employment, either fired or transferred to an undesirable position or demoted, or your job duties substantially and negatively changed, then in order to pursue an employment law case under Title VII, the first thing that you have to do, and this is a prerequisite, it's an administrative prerequisite. If you do not do this, you do not have a case. The first thing that you must do is file a charge with the Equal Employment Opportunity Commission in Birmingham, Alabama. And you must do that within 180 days of the adverse employment action against you. If you don't do that, you do not have any opportunity to bring a lawsuit under Title VII. You have to do that if you feel you've been discriminated against. You have to do that if you feel you've been retaliated against for previously bringing an EEOC charge or for opposing practices that are illegal under federal law. Then the next step is that the EEOC investigates that charge, and after a period of time, which is usually right around 6 months, they will issue some sort of determination on your charge. Either they will find cause to believe that discrimination exists, and then they'll go forward into a mediation process or some other process. The reason I say they'll go forward into some other process and I don't mention it any further is that I never see a cause finding, ever. Most of the time the EEOC says, we can't decide one way or the other. So we're going to issue you a notice of right to sue. And within 90 days of this notice of right to sue, you can take your complaint and you can have your private lawyer bring a lawsuit on your behalf for discrimination. And that is what I do. That is a large part of my practice. Those are that's the administrative process that gets me to a point where I might actually be filing an employment law case in federal court here in the Northern District of Alabama, or a sexual harassment case, which is, of course, a case under Title VII. Now, I told Alan that I was going to primarily focus on sexual harassment this evening. First, I do want to talk about two new United States Supreme Court cases in the employment area. They are 2013 cases, and they're important to me in my practice, and you might find them interesting. The first one is Vance versus Ball State, and it is a racial harassment case where summary judgment was affirmed. Now, does anybody here know what summary judgment is? I see some head nods and I see some blank looks, so I'll tell you as best I can. When you file a lawsuit as a plaintiff, the plaintiff goes through a period of time where they present their evidence to the court. They develop their evidence during what's called a discovery period, where you can ask questions of each other and send requests for documents back and forth, take depositions, this sort of thing. And then when all the evidence is developed, the court will set a deadline, and the defendant will test your evidence against the law and see if your facts are sufficient under the law that maybe a jury, if you're lucky, will find in your favor. That testing, where the facts of the case are tested against the law, is called a motion for summary judgment. And of course, the judge decides if your facts, as have been developed and are presented to him, are sufficient under the law that a jury has the option of finding for you. As you can imagine, the defendants don't want a jury trial. They don't want the plaintiff to have an opportunity to have their day in court and to present their evidence to a jury. So they work very hard on these summary judgment motions. And if the plaintiff has not got each item of proof prepared and presented to the judge, then they will lose on summary judgment. And this is exactly what happened to this lady in her racial harassment case. She lost on summary judgment at the district court level. She never got to trial. What's important about this Supreme Court case, because of course after she lost at district court level, which was right down here on Home Street for us, she carried the case to our Circuit Court of Appeals, which is the 11th Circuit over in Atlanta, and lost there, and then it was appealed to the Supreme Court to make, and they took the case to make some decisions and to give some guidance on what the definition of a supervisor is in Title VII law. Now you think we all know what a supervisor is, right? I mean, we know what it is. But apparently we did not, because the Supreme Court has now told us. Under Title VII, an employer's liability for workplace harassment depends on whether or not, in part, depends on whether or not the person harassing is a supervisor or just a coworker. And further, if it is a supervisor that's doing the harassing, liability depends in part on whether the supervisor has taken a tangible employment action, and that's a term of art. It means a big change in your employment status for the negative, hiring, firing, failure to promote, reassignment with significantly different responsibilities, or a decision causing a significant decrease in benefits. These are tangible employment actions. If the supervisor's harassment results in a tangible employment action, then the employer is what's called strictly liable. If you can prove the supervisor did it, and there's a tangible employment action, employer's liable, okay? Now, if the supervisor action does not result in a tangible employment action, it's harassing, for example, because of sex, because of race, in this case it was race, but the person didn't get fired or demoted or transferred or whatever the tangible employment action would be, then the employer can try to prove a defense. And if they prove that defense, you're out of court. If there's no tangible employment action taken, then the employer may not have any liability at all if they can establish that the employer exercised reasonable care to prevent and correct harassing behavior, and that the plaintiff unreasonably failed to take advantage of the preventative or corrective measures and opportunities that the employer provided. Now, what that means is you didn't follow the handbook, usually, okay? So you can see that whether or not somebody is a supervisor is important, because if it is a supervisor and if there is a tangible employment action, then automatic liability. If it is a supervisor who didn't do a tangible, who didn't cause a tangible employment action, or if it's a coworker, just a coworker, then in that case, the employer may have an out. They may have a defense. So there was a push to have supervisors who you and I would call a supervisor, somebody who can assign you work, defined as the supervisor under our law, under the federal law, because in that way, if there was a tangible employment action, hey, you know, strict liability. But the Supreme Court said only if the supervisor can take a tangible employment action are they truly a supervisor for Title VII law. Now, what happens if a coworker who is allowed to give you daily tasks, who's allowed to tell you what to do, is the harasser? And this is particularly important in a sexual harassment context. Well, the court said, well, in that case, the person who's harassed can prevail in court by showing that the employer was negligent in permitting the harassment to occur. And they said the jury should be instructed that the nature and degree of authority wielded by the harasser is an important factor in determining negligence. What does that mean? Well, I guess we will find out, because that is a new standard. It's sort of complicated, and it hasn't been fleshed out in the district courts where these trials take place and where the law is sort of developed, and then, of course, it gets tested on appeal. The fear was, by the plaintiff, was that employers will attempt to insulate themselves from liability by, say, empowering only the HR director to take tangible employment actions. Of course, we all know the HR director isn't out there telling everybody what to do. And indeed, that is what most organizations are doing. So, so you see what kind of fights you have as a plaintiff when you're trying to prove not just that the harassment occurred, but that the employer is responsible for that harassment. So that's one of the new cases this year. Another new case is University of Southwestern Texas Medical Center versus Nassar. That was a religious and ethnic harassment and a constructive discharge and retaliation case. In this case, the plaintiff was not thrown out of court at the summary judgment stage, as they were in the preceding case, but in this case, the plaintiff tried their case and won their case in the district court. This case illustrates kind of how hard it is to keep those wins sometimes. When the case was taken up to the Fifth Circuit Court of Appeals, the Fifth Circuit threw out the discrimination decision that was in favor of the plaintiff, but affirmed, said, you know, you've done the right thing on the retaliation case. So the plaintiff now has lost half their case, but they still have half their case. The employer then appealed that case to the United States Supreme Court. And we now have a new standard for proving retaliation cases. The standard to prove a discrimination case is that the motive has to be a motivating factor. The discrimination has to be a motivating factor in whatever action was taken. But it doesn't have to be a situation where, but for that bad motivation, the discrimination wouldn't have taken place. The discrimination could be one of the reasons, in other words, that the action was taken for a harassment case, for a discrimination case, for example. But the Supreme Court has said there's a new test for retaliation. Retaliation occurs when you've already complained, either formally through the EEOC process or informally through a company process, and then something bad happens to you because you complained. In that case, it has to be but for causation, but for the complaint that you made, the or the negative thing, and usually by then it's a firing because you've complained, so you're going to get fired. But for the complaint that was made, there would have been no retaliation. And that's a much tougher standard. I see a question. Yes, ma'am.
Now I say that the major problem in proving discrimination of any type under Title VII is that the witnesses have to protect their own jobs. They're the colleagues, they're the co-workers. They're not going to tell the truth under oath. They're going to protect themselves. They are taught by their attorney to say, what to say to protect themselves. That's what I have experienced with my daughter. We went all the way to the U.S. Supreme Court.
Really?
We lost. Everybody lied under oath.
One of our participants has shared that the biggest problem with with proving discrimination cases is that you cannot get corroborating testimony from other coworkers. They are in fear of their jobs, and they, if they don't tell outright untruths, they have an astonishing lack of memory. And so, and actually I will get to that a little bit later. I've got some illustrations of that. So now we're going to get on to what I know that you all are just dying to hear about, and that is the top 10 things you need to know if you're sexually harassed at work. I found an article when I was poking around on the internet and getting prepared for this evening, and it was written by a Florida lawyer named Donna Baldwin. So I have her to credit. I found the article on jobs.aol.com. Top 10 things you need to know if you're sexually harassed at work. And I'm going to read them to you, and then I thought it would be fun to see if I could find some cases that would illustrate why this is very good advice. So here are the top 10. Don't quit. Follow the policy. Put it in writing. It doesn't have to be sexual. Single incident is probably not enough. They don't have to fire the harasser. The employer has to investigate. Keep reporting. You are probably not alone, and sometimes it's time to quit. So with that outline, I'm going to talk to you about some of these pieces of advice, and what struck me about this is that this is the advice I give in my own office several times a week, either all of it or most of it, because some of these concepts are hard for people to understand, just like employment at will is hard for people to understand when it happens to them or their loved one or their child who they're now going to have to support or whatever that is. It's just hard to understand. Yes, it really does mean no reason at all. So here's these 10 pieces of advice. And number 1 is don't quit. And I picked out the case of Sawyer versus Jackson, which is an 11th Circuit 2013 case to talk about, to help us understand why you can't quit. In this case, there was protected activity. A lady filed an EEOC charge based on gender discrimination. There was adverse action. This lady was suspended a week without pay. There was some relationship to the filing of the EEOC charge and the adverse action, at least prima facie, that means on the face of it, because 9 months later, she was suspended after filing this charge. And the courts find that if the time frame is close, there'll be some, at least on the face of things, some causal relation. So once you have those things, then the employer can articulate a legitimate non-retaliatory reason for why they did what they did. And in this case, the employer said, hey, wait a minute. We suspended this lady because she wouldn't participate in a work project. At that point in time, the lady has to come forward and say, you know, no, that's not true. That's just a pretext. She said, hey, wait a minute. You were asking me to violate government regulations. And besides, nobody gets suspended for the first time, for first-time discipline, and I've never been disciplined before in my life. And the employer was able to refute that by saying, well, we warned you 5 times in writing that this was going to happen if you did not participate in that work project. So what happened? Well, the court said there was insufficient evidence that the reasons this lady was suspended were pretextual, and the court properly granted summary judgment on this claim. In other words, she didn't have causation. She was discriminated against by this suspension because she had 5 written warnings. Okay. So what happened after that? Well, the supervisor then continued picking on her because he did. Made a comment about using sick leave. Said, you know, now that I've suspended you for a week, I'm going to suspend you some more because you're still not doing your duties, and wouldn't approve the travel request, and took her computer away and gave it back, but took it away for a while. These sorts of things. So now Our Lady quits. And the court said, guess what? Do you think she could quit under those circumstances? No. Anybody else? No. No. The court said, this is not a constructive discharge. You do not get to quit. To show constructive discharge, the employee must prove that the working conditions were so difficult, so unpleasant, that a reasonable person would have felt compelled to resign. And making a belittling comment about sick leave use, warning them, telling them you're going to get more disciplinary action if you keep on, you know, slacking off. I'm not going to approve your travel, and taking away your computer for a period of time, that wasn't enough. What's enough? Well, in a case where the employee was stripped of all responsibility, given only a chair and no desk, and isolated from conversations with everyone else in the workplace, that was constructive discharge. So as you can see, that's a very high burden, and most of those cases fail. So don't quit. Number 10 on the list, which I didn't say I was going to take these in order, is sometimes you have to quit. What I tell my clients frequently is that jobs are better than lawsuits. That's one of my favorite little sayings. If you can keep your job, keep it. But the other thing that I say frequently is safety first. If you're in a threatening situation, a physically threatening situation, if it has reached the point where your blood pressure is sky high every day and your doctor keeps telling you you are going to have a stroke. I've had clients who have suffered debilitating, and I do mean debilitating, anxiety and depression as a result of having to go back into this workplace over and over again. Well, maybe you should quit. Maybe you should quit. Will you have a lawsuit? Probably not. But you'll have your life. And so sometimes you just have to quit. Number 2 on our list of good advice is follow the policy. And why should you do that? Well, company has to be on notice if your supervisor is harassing, but there's no tangible employment action. Company also has to be on notice if your coworker, if a coworker is harassing, company has to be on notice. If the company is not on notice, then the plaintiff unreasonably fails to take advantage of preventive or corrective opportunities that are employer provided, and the case fails. But once an employee complains to the designated person in say in your handbook, the employer has actual notice of whatever behavior you're complaining about. So if that policy says if you complain to, say, your general supervisor, and you complain to that general supervisor, then Human Relations over in Atlanta can't later come back in and say, well, we didn't know. Too bad. You complied with the policy, that company's on actual notice, and then they have to do what they have to do, or you have a lawsuit. Number 3 is put it in writing. This is practical advice. This is purely practical advice. There's no law that says you have to put your complaints in writing. Sometimes the employers say you have to. Well, guess what? You don't. But how are you going to prove it if you don't? What's going to happen if you have a supervisor who is the supervisor you're supposed to complain to if you have sexual harassment on the job, and that supervisor doesn't do anything, and later on you sue? Well, one of two things. The supervisor is going to completely forget that you ever had that conversation, because of course they got to protect their job. Or the supervisor is going to remember that you had the conversation, but is going to remember it as something that was just a disagreement in the workplace, just some generally not getting along. Certainly not that this was harassment because of race or sex or national origin or whatever harassing behavior you're complaining of. So not only should you put it in writing, but you have to be clear that this behavior you believe is happening because of the illegal motive. No because of, you're going to be in trouble. So put it in writing, not because it's the law, but because you'll fail on your facts somewhere down the way if the situation is not addressed and you end up in litigation. Number 4 and 5, it doesn't necessarily have to be sexual harassment to require compliance with the policy. It can be just general harassment because of sex, or general harassment because of any other one of the Title VII prohibited discriminatory reasons. It doesn't have to be sexual, so you still have to comply with the policy. And a single incident is probably not enough. Now, this is not an 11th Circuit case. It's not even Northern District. It's not even an Alabama case. This is an Eastern District of Virginia case from 2012. But it's an interesting case. And so I have put it in here because I thought you might like to hear about it. This is a retaliation case, and summary judgment was granted. It means this poor lady had her case thrown out of court. Lady was a salesperson, and after she closed successfully this really difficult sale, I think she sold timeshares, her male supervisor was in such a celebratory mood that he reached out and whacked her on the hee-honey. The plaintiff wrote a note to the proper person saying that she was offended by this behavior. And after she wrote a note saying she was offended by this behavior, she was fired for having attendance problems. Now, this is an internal complaint, and there's a difference between someone who's claiming retaliation for making an internal complaint versus someone who is claiming retaliation for filing an EEOC charge. If you're filing an EEOC charge, it's under what's called the participation clause. And that means you filed it, you were retaliated against, that's as far as you need to go. Under the opposition clause, which is what an internal complaint is filed under, you opposed unlawful discrimination in the workplace. There's an extra step. The plaintiff has to prove that they reasonably thought they were opposing something prohibited, in this case, prohibited sexual harassment. She has to reasonably have thought she was opposing prohibited sexual harassment. She doesn't have to have been right about that necessarily, but she has to have reasonably thought that she was opposing prohibited sexual harassment. In other words, do you think it's reasonable that if you complained about being whacked on the hee-honey by your supervisor, and you're a female, and your supervisor's male, that it would be reasonable to assume that you were opposing sexual harassment? I'd like to see a show of hands. Who thinks that it would be reasonable to think that you were opposing sexual harassment? Let me see a show of hands. Yeah. Well, guess what? You would be wrong. And this is why. It's an interesting case. But for whatever reason, the plaintiff testified in her favor, and this is by the time it's in litigation. She testified that she didn't think that he would have hit a man the same way because a man would have hit him back. Okay? So I'm still thinking, well, yeah, of course. This is reasonable that you would think you were opposing sexual harassment when you complained about that. But she also testified she had no other problems with her supervisor. There was no other inappropriate comments, no other inappropriate touching. She'd never seen him behave inappropriately with anybody else. She didn't really think the slap on the behind was sexual in nature. She didn't think he was trying to hurt her, and she didn't have any problems with him, and she didn't really want him to get in trouble. Well, it was held that no reasonable juror could conclude that single isolated incident complained of was prohibited sexual harassment under the law. And what the court said, and we've heard before, Title VII is not a civility code. Now, I'm not recommending that anybody go out and whack their subordinate on the hee-honey, okay? No matter how happy you are about how much money you just made. But in this particular case, there was no liability for that. And lastly, I've got these last 4 pieces of advice, and I've got them all put together to discuss in a case that happened right here in Huntsville, Alabama. Baldwin versus Blue Cross Blue Shield of Alabama. And these last 4 pieces of advice are, they do not have to fire the harasser. Keep on reporting. The employer has to investigate. And guess what? That means you probably will not have a confidential complaint because the harasser is going to figure out who complained. And you are probably not the only one that this has happened to. These are the last 4 little pieces of advice, and this case illustrates all of them. Now, if they don't have to fire the harasser, what is the employer's duty? What is it? Meritor Savings Bank versus Vincent, which is a Supreme Court case, an old one, says that Title VII affords employees the right to work in an environment free from discriminatory intimidation, ridicule, and insult. An employer is liable for failing to remedy known hostile or offensive work environments, and employers have an affirmative duty to eradicate hostile or offensive work environments. Okay? So that is the employer's duty, and that is a Supreme Court case. Now, I usually issue a little disclaimer, and I'm going to do it now. This is a family-friendly hour that this will be shown, and the topics in this case are a little bit racy. I'll do my best to use the letters instead of the whole words and to describe it in a way that you all know what I'm talking about, but hopefully those 10-year-olds at home don't, including mine. This is a summary judgment case out of Huntsville, Alabama. The boss regularly used profanity in the workplace. Women were babes or bees. Men were called by profane references to the male anatomy. And this charmer regularly referred to his own wife as an effing bee in the workplace. Needless to say, this subordinate objected to this behavior, as well as him approaching her and literally breathing down her neck, zipping and unzipping his fly in her presence, manipulating his male parts through his clothes, and telling her that she could go on down the hall and tell a certain male colleague that he could come up here and perform an act upon him, bragging about having a physical altercation with his wife, which scared the plaintiff because she knew then that he was willing to be physical with women, and then told the plaintiff quite unashamedly that he needed to hire a man for a certain position in the company, someone who had male private parts just like she did, and he meant the one that there are two of, and he was not going to hire the female candidate who had been presented to him, who was a tramp and an S. So this is what was going on in this particular workplace. In addition, he'd had an on my team conversation with our female plaintiff, wherein he threatened her and pointed his finger in her face and such as that. She had to take a work trip down to Birmingham, a banquet, and after that, I got the impression there was liquor there, but I don't know that, just got the impression in the case from the way it was reported. But during this banquet, he began propositioning her and telling her that she ought to just stay over the night with him and nobody would know, and etc. And of course she refused, and he propositioned her multiple times, even including on the drive home, saying that he was going to be at her house when she got there. He, in his office, on an occasion when she was there just with him, he said, "Hey babe," and then requested a sexual act. And then there was screaming and raging anytime he was just unhappy with her about general purposes. No one corroborated this behavior. Okay? No one corroborated this behavior. The company had to investigate, right? And they did. No one corroborated this behavior. The plaintiff insisted that what she said was true, and she demanded that this guy be fired. And here's when it went bad for her. The HR folks said, "Well, we're not going to fire him. And we don't have to fire him. We are going to refer you both to counseling because clearly there's a problem here." The plaintiff was incensed. She says, "I'm not going to counseling. I don't have to do that." That's, I'm sure she said lots of things about that idea. So after several conversations about counseling, HR said, "Well, fine, you can accept a transfer to Birmingham then." Well, that would have required her to start all over pretty much in her job. And she lost all her business contacts, she lost her book of business, the whole bit. She said, "I'm not doing that either." And guess who got fired? She sure did. And what did the court say? Well, court says warnings and counseling of the harasser are enough when allegations are substantiated. In this case, they weren't. Talking to the harasser and telling the complainant to report any further problems as an initial measure as an initial measure is enough to constitute immediate and appropriate corrective action. Giving the harasser a verbal warning and transferring the complainant to a different work group, immediate and appropriate corrective action. Issuance of a counseling memorandum to the harasser is sufficient. Counseling may be a sufficient remedy as a first resort, and what is appropriate is dependent on the facts. In this case, there was no tangible employment action, and the plaintiff unreasonably failed to take advantage of the preventive or corrective opportunity that the employer had provided. In other words, counseling. This is a case where the complainant refused to cooperate with the first step in addressing the problem. She did it because she wasn't happy. She refused to give Blue Cross a chance to remedy, said she wouldn't work with the guy again, and the complainant does not get to choose the remedy. And if that weren't enough, she complained too late. She waited 3 whole months to complain. That is not prompt, early, or soon. Now, why did she wait? Because she was afraid that she might get fired, which turned out to be very well-founded, and that silence was best and would best serve her career interests. Her goal was to just get along. Now, how many times have you said that? But what did the court say about that? While we have recognized that filing a sexual harassment complaint may be uncomfortable, scary, or both, the problem of workplace discrimination cannot be corrected without the cooperation of the victim. And the court kindly acknowledges that the law presents employees who are victims of harassment with hard choices. Either fess up, assist in the prevention of the harassment by reporting, and be sure to say the because of, or lose the opportunity to successfully prosecute a Title VII case based on harassment. So keep reporting, and in this case, she was probably not alone, but she jumped the gun. She needed to have gone along with it, kept her eyes open, kept her ears open, documented, and some of those corroborating witnesses might have come out of the woodwork for her. Yes?
What should she have done to prove her case?
Well, she had to have some corroboration. You know, more than one way to do that, but I'm getting the high sign. So, right afterwards. Thank you.
Ladies and gentlemen, thank you so much for watching and enjoying the program with us. Tonight we graduate. We've been through the People's Law School, and as it's turned out, some of our students have their own opinions and about what they think about the program. And I'm going to ask, for example, Gwen, what do you think, my friend?
I think all presenters did an excellent job, and that the show should be rated #1 on cable TV.
Thank you so much. And I see Mr. Martin here has got his, look at that diploma right there, look at that thing, it looks pretty good. Have you enjoyed it?
Thoroughly enjoyed it, learned a lot.
Thank you so much.
Miss Smith, did you have a favorite?
Oh, yes, you.
Oh! Okay, I wasn't begging for that. Did you have a second favorite?
I think they were all fantastic. I've learned a lot from each one of them, so it's been a great program.
Did you enjoy it?
Yes, I did very much. I learned some new laws I didn't know before. So I will be back.
I enjoyed it very much. Very educational and sometimes very entertaining.
Yes, I believe it. Now, here we go. What do you think about our program? Did you like it?
I did, and I thought a great variety of topics that were very practical were covered.
Thank you, thank you. And here we've got Mr. Joe Lee. His name is not Jolly, it's Joe Lee, like Angelina Jolie. And so he's corrected me earlier in the program, but what have you thought?
It's excellent, Alan. You've outdone yourself this time. This is the fourth time I've taken a course since I retired, and that doesn't count the 20 times that I watched it on TV before I retired.
Wow.
But it just gets better and better.
Thank you.
Keep up the good work.
Thank you so much.
Did you learn anything useful?
Useful? A lot. I did not know what to expect. My brother and his wife had been attending in the past and had told me a little bit about it, and what they said was A+.
Well, I've always wanted to learn a little bit about the law, and this has really been helpful. I've been here twice, and I've learned a lot of stuff both times.
Now, Mr. Priest, and I say Mr. Priest, this is Ken Priest. He and I were classmates, and we're buddies. Remember when you rode down to my house first time, I think, in about the 5th grade on your black bicycle?
With my black clothes.
With your black clothes on.
That's right.
It was about 10 o'clock. Late for a 10-year-old. Have you enjoyed it?
I have. I've thoroughly enjoyed it. I've found it to be entertaining, educational, and with a variety of subjects, so that we got a diversity of the types of law that was covered. I thought that was very, very helpful.
Thank you. Thank you.
My only regret is you've been trying to talk me into this for 4 years, and I waited to this year to get here.
Now this girl, this is Beverly Slack. She knows everything. She's been a court reporter forever. That's because her mother, Janice Sanford, is a court reporter forever. And so she knows all the tricks of the trade. But this is her first time here to the People's Law School. And what do you think, Beverly?
I love it. Yeah, I'm hard to be around the next day because I feel like I have rights and you have help. I mean, seriously, I get feisty. I really do. Ask Mom. It's a pick-me-up. It's really excellent.
Wonderful.
Yeah.
Wonderful. Thank you so much. And Stephen's just graduated from law school. How about it, Stephen?
Fantastic program. I think just as a previous law student, this is not only a great review, but a great way to meet new attorneys and to meet the people in the community that I want to help serve in the future. So it was a pleasure to come and participate.
Wonderful. You know, when I was your age, I didn't know a lawyer hardly at all, and I wish there had been a program like this so that I could do something about it. And I'll also tell you, with that voice of yours that talks like that I can't keep using it. Perfect it, will you?
Tell me what motivated you to come all these weeks, night after night.
Well, I just like the insights that were provided, and I really liked the Alabama slant that the presenters provided. So we just didn't get a cereal box law review. It was geared towards us.
Right. And Ms. Ruzicka, have you had some interesting things to talk about at home?
Oh, yes, we have. Yes, we have. Some of the things we agreed about, some of the things we didn't, but the presenters were excellent.
Thank you.
And Heidi, how about it? What do you think? I know this is not your first time to be here.
That's right, about the 5th time, I think. So it's a wonderful benefit to the community, and I appreciate your doing it all these years. Giving back. Thank you.
I'm glad to do it. And I know Heidi is very involved with being a second-generation German person that has come here with the rocket team. She knows a lot about it and is deeply involved in it. And I hope that you will let all of your friends involved in those programs and the paperclip things know about it next year. So maybe
Always
they'll
do,
come.
yes.
Thank you so much. And what do you think?
I'm a transplant to Alabama, and part of the reason I wanted to come here was to see if Alabama is really as different as I've always heard.
Spit it out. Where are you from?
I'm from Wyoming.
Oh, yeah. Home of Dick Cheney, right?
That's right.
And you just want to
Yes.
be fair when you talk about us. You won't hurt our feelings. We don't care.
Well, you know how you need a visa to come down here.
Sure.
Yeah, there's probably a reason for that. But I love the enthusiasm that you have, and I'm so glad you do this. It's been very enjoyable, and I've loved every minute of it. I really have.
Thank you, and thank you for coming. Yes, sir, Ray. Talk to us.
I've learned quite a bit since I've been here, but dealing with you, Alan, only thing I can really say is I'm in the wrong profession.
Well,
the most of the time when I come, it's a sad occasion.
Right.
So, and I've sit here through these sessions and having people to talk back to me. Most of the people that I deal with don't talk back to me.
Well, And you did a funeral just a few hours
Just
ago.
a few hours ago, yeah. So I've learned quite a bit, and it's just been I've had a wonderful time.
I've enjoyed it. All of it has been very interesting. I enjoyed the elder law. You were awesome tonight. I mean it. Thank you.
And Mr. Darwin Moss.
Hey.
Tell me about it.
I enjoyed it. I think the presenters did their homework, and it was nice to have experts in their field talking, and they always answered their questions very distinctively and informative.
I'm so glad that Mr. Moss came because he lives about a block from my office, and I literally went down there and got him and made him come the first time.
That's a fact.
I want to ask you if you two always agreed on everything after what you heard here.
Yeah, most everything.
Yeah, definitely most everything, according to Mr. Brinkley.
Well, tell me, will you want to come back again next year?
Sure.
Definitely.
Tell me about it. What do you think? Have you enjoyed the programs this year?
I've loved the programs this year, yes. I'm happy with all my fellow students here, and I just want to say I learned a lot from you. I learned, and when you were talking, you know, it's the way you stand, the way you yeah, you assert yourself. I like that.
I love
confidence. It's confidence.
These people here that I met, these attorneys, I really liked them. They're professionals, and I felt like I could trust them if I needed their help professionally.
Ladies and gentlemen, I want to thank you so much on behalf of the People's Law School. Come back and see us. We're going to start again next year, and we'll see you soon.